Hi, everyone. In this lesson, we're going to talk about recruiting, testing, and reviewing. So jumping right in, recruitment. We have to think about all these steps in the process of bringing somebody on board, and then we can look at how we manage them while they're onboarded. But first, we have to recruit them. So we have to ask ourselves some questions. So how do we attract applicants? Is there anything about the process of recruitment that might tend to favor or exclude certain protected classes? Of course, the idea is to recruit the most qualified, the best people. But in the past, some forms this has taken is some high-level institutions like corporate entities might be recruiting only from, let's say, like the Ivy League schools or something like that. And if we look at the Ivy League school student population and we find out that there is some significant disparities with regard to race or religion or national origin or whatever it might be, then what we might end up with is a little bit of bias in our recruitment pool. So it doesn't necessarily mean that what I'm doing is illegal, but it's something to think about as we're going about doing our recruiting activities. So some laws that are involved, well, there are federal, state laws, and common law to think about. So the federal laws that are applicable here, we're looking at Title VII of the Civil Rights Act of 1964, which covers things like race, color, gender, national origin, religion. We're looking at the Vocational Rehabilitation Act of 1973, which was a precursor to the Americans with Disabilities Act of 1990, both saying that we shouldn't discriminate against people who have disabilities. The Age Discrimination in Employment Act of 1967, saying we shouldn't discriminate against people who are 40 or over. The Immigration Reform and Control Act of 1986. We'll dive deeper into the IRCA in the national origin section, the national origin lesson of the course. There also are state statutes, so each state can set up their own laws that can provide protections based on these protected classes. They can be more protective than the federal laws, and then that would apply within that state. They just can't be less protective, or if the law is less protective, then the federal statute would kick in, and that would be the one that would guide employment decisions in that state. So depending on which state you live in, it can provide more protection than federal. It just can't provide less protection. We also have to think about common law. So when we're talking about common law, we're talking about court cases and precedents that build up over time that create this body of law. So we're thinking about things like misrepresentations and fraud, and states, of course, can have statutes about misrepresentation and fraud as well. But then we're looking at court cases to decide how exactly that statutory language is going to be interpreted and applied. But so as an employer, I'd have to be careful when making statements that the applicant might rely on when considering this job. I don't want to overpromise. Things like promising a raise after a certain period of time and then not granting it, lying about the essential nature of the job and its duties. If I find out during an interview that an applicant has a mistaken belief about what the job is and I don't correct them because I'm just trying to get them on board no matter what, that's the kind of thing that might create an issue for me later on. Portraying different images of the job to different classes in order to either attract or repel certain classes. Really, we're thinking about protected classes here because I can discriminate on a lot of things, like if a person is smart or not smart, or if they're diligent or not diligent, or if they show up on time or not, things like that are perfectly fine to discriminate against. We just want to be careful about those protected classes. Moving on just a little bit. Okay. Applying our regulation to recruitment practices. So we have to think about all the steps along the way just to make sure we're not missing something. that might get me in a little bit of trouble later on. So things like the advertisements that we put out. Is there any language or maybe even an image in there that might tend to favor or exclude protected classes? We can go way back in history before these civil rights acts, and we can find job ads that will say things like Irish need not apply, or we're looking for somebody and it has to be a white person. Stuff like that used to be allowed, but of course not anymore in the United States. So we have to just look at that language, look at the images we're using just to make sure we're not excluding people. Word of mouth recruiting is what a lot of small businesses do because they're not putting out a lot of advertisements, not paying a lot of money to do a lot of these recruitment efforts. So we're just relying on word of mouth, and that in most cases is fine. There are just some edge cases where we have to look at if there might be a discriminatory impact or a disparate impact. And I think we've mentioned that before, and we'll dive deeper into it later on in the course. But the idea is we have to look at and say, well, the advantages of word of mouth recruiting, the advantages are easy. It doesn't cost me anything. If I have good employees going out there and telling their friends, and we're kind of counting on them to vet their friends, and hopefully they don't send me somebody that they wouldn't be able to vouch for. So there's a lot of advantages with word of mouth. We just have to balance that against a possible discriminatory impact if the workforce is already imbalanced, if it's already skewed with regard to some protected class. It might make a difference if the employer actively asks employees to refer friends rather than just passively letting it happen. Because if I'm actively asking employees to refer friends, then it seems I'm taking more of an active role in that, and that might increase the potential of my liability. But again, this is not going to be very common. In most cases, word of mouth recruiting is absolutely fine. Promoting from within, if that's my preference, again, probably completely fine. We just have to be careful for those edge cases, again, where if my workforce is already very imbalanced in such a way that just promoting from within is going to have this disparate impact, tending to keep certain protected classes out of the workforce altogether. Venue recruiting, where are we going to actually do the recruiting? So if I'm only going to schools that only have certain protected classes, if this school skews very white or very black or very Asian or very whatever it is, it's at least something that I should consider. Again, I'm usually going to be okay doing these things, but over time, and as a company grows bigger and bigger and draws more scrutiny from the public, it's the kind of thing that might come into play. Let's say I only take in walk-in applicants. Again, probably okay, unless there's some disparate impact in there. Again, edge cases. Neutral solicitation is kind of what we're going for, using, this talks about gender specifically, but we kind of want to be neutral with regard to all the protected classes here. So using gender neutral language, making sure not to use language that might discourage any class from applying, because even if I don't outright say I'm looking for a man to do this job, there might be something about the language that might be off-putting to women and keep them from even applying in the first place. Okay, so we talked a little bit about the recruiting. Now we're going to actually have people coming in and applying for jobs. So this is the information gathering and selection phase here, where we're going to have applicants, and now we're going to have to gather some information and make selections. We're probably not going to just hire everybody who applies. Probably. It depends on the state of the economy. But in the application phase, our questions should be used and geared toward business-related and non-discriminatory reasons. These questions are going to be okay in most cases. And if you're a business person and you're thinking about hiring, if you gear your mind toward just simply finding the most qualified person who will be the best fit for your organization, you're going to avoid a lot of these claims of discrimination and whatever else might be going on. But the reality is that we're all humans, and we have certain even internal biases that we might not even be aware of. So it's a good idea to take a look at everything we're doing just to make sure that we're not harming our business by severely restricting the amount of people that would be coming in and applying for jobs. Now, there are some questions that are outright prohibited and some that are technically sort of legal but can just get me in trouble. So first, the prohibited questions are asking in this phase about a person's disability, or if they have one, asking about any health problems they might have, asking about workers' comp claims history. Those are prohibited by the Americans with Disabilities Act. Now, it's not that I can't find out about a person's disability and health problems, but that would be later on after we've already made a job offer. Then we can dig a little bit deeper into that, but we're just trying to prevent people from being rejected or filtered out before they're given a fair chance to demonstrate that they could do the job with or without some type of accommodation. Okay, questions that aren't outright prohibited but could open me to litigation later. Things that are asking about age, about sex or gender, about religion, about a person's marital status, about their nationality, about their ethnicity. I have to make sure, or I should make sure, that my questions are related to the position if I'm asking about something. And it's not that I can't talk about age, gender, religion, all that stuff. It's just that if somebody, let's say I ask, we're in the South, it might be common to say, well, where do you go to church or something like that? And that seems like a very harmless question, but built into that is the assumption that, number one, a person goes to church in the first place. Number two, if they say what church it is, I'm going to know what religion they belong to and what denomination. And if they're not hired later on, then they might go back and say, hey, is my not being hired related to the conversation we had in the interview? And it could just open the door to problems. So it's best just not to talk about that kind of stuff. That was specifically for the application, but the same thing for the interview. So when we're thinking about an interview, same prohibited questions, same questions that aren't prohibited but are still a bad idea. And we want to make sure that the interview process is as equal as we can make it, reasonably, within some reasonable restrictions there. So how long are people being asked to wait before being brought in for an interview? The number of questions that are asked, the number of interviewers that are in the room, how long is the interview? If we find out that we're treating people unfairly, we should look at that. Okay. Now, many of us at this stage in our lives have been hired on to do some type of job, and some of us in the class probably are the ones that are doing the hiring. So on either end of that, we're at least familiar with the idea that an employer is going to, most of the time, want to do a background check. This is a good idea to do for the reasons that we'll get into here in just a minute. If an employer doesn't do a little bit of a background check, at least some kind of background check, to look into an applicant's histories, it could open me up for a negligent hiring claim later on if an employer does some kind of harm. Some keywords that we're looking at here is the background check reasonable and responsible? What would a reasonable employer do in similar circumstances? So an easy example is if I don't do a criminal background check on somebody, and then my employee goes out and assaults somebody or steals property from somebody, from a customer. And it's only later on that we find out that they had this extensive criminal history. I could be on the hook for a negligent hiring claim because I didn't do my due diligence to find that out ahead of time. And maybe that whole situation could have been avoided if I had done the background check. So a lot of people will sort of juice their resumes and stuff to misrepresent some academic credentials, to misrepresent their work experience, and sort of boost themselves on that. So verifying the information is a good idea, just to make sure people have the qualifications that they claim to have, rather than just trusting what they put on a resume or a cover letter or whatever information they're giving me, job application, whatever it might be. We do run a negligent hiring risk if I hire somebody that is incompetent or unqualified, if I knew about it or at least should have known, meaning that I should have done a background check and I didn't, and if the employee's act or omission caused the plaintiff's injuries. We're imagining it where somebody has brought a lawsuit against me at this point. And finally, that my negligent hiring or retaining of the employee was the proximate cause of the plaintiff's injuries. So that's the kind of test that a court would walk through to try to determine whether I, as the company, am going to be liable for whatever happened. I gave you a link to a case in North Carolina that dealt with this, where somebody was hired on, caused some physical harm to somebody else, had a criminal history that we should have known about, but we didn't find out about. And so you can click that link if you want to read through the case information to learn more about it. But it is the kind of thing that happens relatively frequently. Doing a, like I said, criminal background check is allowed. The conviction record check is allowed. There was a time when people would ask on an application if anybody had ever been arrested before. That's a little bit more dangerous to ask about because of some disparate impact concerns, because certain populations tend to be policed more heavily. If you live in a certain neighborhood, you might have more interaction with police officers. It raises the chance that you may have been arrested, even if you didn't do anything wrong. So it could be that somebody has an arrest record, even though they don't have any kind of conviction record. So that's the kind of thing to be aware of. So most companies have caught on to the fact now that if they're asking a question on an application, they're asking about whether they've been convicted of anything rather than have they been arrested for anything before. North Carolina specific statute here, section 15A 146, says that if a person's charged with a crime and the charge is later dismissed or found not guilty or not responsible, then I can apply to the court to have it expunged from official records. And then when expunged, I could legally omit that information from any kind of inquiry, whether that be on a job application, whether that be during an interview. I can legally just not say anything about it because it's been expunged, but there's a process that I have to go through. That's the kind of thing that really shouldn't come into play, because I should be hopefully asking about convictions. But, it hasn't always been that way. Some companies aren't quite up to speed with everything. So anyway, that statute's in place. You can read more about it. I gave you a link. There are some people who think that we should modify job applications to quote unquote ban the box. The box is the box that you check because it's a question on a application that says, have you ever been convicted of certain crimes, excluding traffic violations and things like that? And if I check that box, then the most likely thing is that if a company sees that box has been checked, then they just immediately dismiss that person and they don't give them any further consideration. It's just that application goes into the trash and we're done. Some people think, and this is not any kind of law or anything yet, this is just something people are playing around with on an ideological level. Should we ban the box saying that we don't have that question in that box on the application and we can ask about it later on, but that would at least give a person time to come in and meet and speak to a real person and sort of get to know them and allow them time to explain their history rather than just seeing the check mark on an application and then immediately filtering them out. I haven't seen these ban the box initiatives take root quite yet. We might see it in the future. I would imagine that it sort of depends on what kind of government administration we have in place. but it's something that we might hear about more later on. So if you hear about it, that's just what it means. Now, a lot of companies are also checking credit history because they want to see, they think it has some indication about your responsibility level, your ability to handle finances. So this is allowed. The FCRA, which stands for the Fair Credit Reporting Act, does require that employers notify an applicant and retain or obtain written authorization in order to do this check. And if the employer intends to take adverse action based on the credit report that they pull, then they have to notify the reporting agent, notify of the reporting agency that they used, and give the applicant a chance to dispute what's on that credit report. Okay. And this is off topic a little bit, but that's why it's so important for everybody to pay attention to their credit history, their credit score. Not only does it save you money if you're trying to go get a loan, but it's the kind of thing that can make it very hard to obtain housing because landlords are running credit checks, to get a job because employers are running credit checks. So staying on top of that, it just makes life so much easier rather than just letting it go. Okay, moving on. So almost all companies will, once you get up to a certain level, will start asking for references just because they want some reference point. They want to be able to check with somebody and say, hey, you worked with this person in the past. How are they as an employee and a coworker, things like that. And the challenge there is getting honest feedback from past employers, because we've gotten kind of to a point where companies, especially large corporations, are very hesitant to reveal any real information other than just, well, yeah, they worked here and they either are or are not eligible to be rehired. So, there comes a point where we kind of have to ask whether or not checking references actually does anything. It's probably still a good idea to do. The employers don't have a legal responsibility to provide references, but if you do so, you do have a duty to be honest. You can't just lie to harm a person's career. That can open you up to a defamation claim. On the other side of that, if there is damaging information out there and I conceal it, could potentially open me up to a negligent referral claim. And so the two sides of that coin there are why a lot of companies now are so hesitant to release anything more than just this very minimal information, dates of employment, whether they're eligible for rehire. When I'm looking into people's pasts, I have to just be a little bit careful. If I check too much into things, I might be crossing a line into invasion of privacy, so I don't want to do that. If I check too little, then that opens me to the possibility of a negligent hiring claim, so I don't want to do that. So finding a balance is key here. Now, North Carolina has a specific statute on the books that says as long as an employer is giving honest information about a job reference, then they're shielded from liability. Regardless of that, so many companies are so scared of just encountering a lawsuit, even though they know they would win because it takes time and takes money to defend, that they just have all sort of defaulted to this, well, we're not going to say anything other than dates of employment and eligibility to be rehired. North Carolina also has a statute on the books against blacklisting, where I would, this is the situation where maybe you leave a job on bad terms and you might have a boss that says something to the effect of, well, I'm going to see to it that you're never going to work in this industry in this town ever again. And then they go and smear your name to every other company that they know around just so they're aware of you and so you can't get hired anywhere. And that's what's known as blacklisting. And North Carolina does have a statute about that. But key in there is, is the information that we're spreading true or false? If it's true information, then maybe it's okay. Of course, if it's false information, then it's not okay. probably a good idea to have applicants sign, maybe this is the kind of thing, if we're trying to get more information out of references, maybe it's a good idea to have applicants sign a statement releasing previous employers of liability for providing truthful references. And then send that statement along with the request for references to the past employers, because then they'll see it and say, well, the applicant's already released me for liability, at least for truthful statements, not for defamatory statements, of course. And maybe that gets them to open up more and more. Especially with small businesses, they might be more willing to actually give you real information. Once you get up to a certain corporate level, then it's just very hard, so it's challenging. That brings us to the next topic, which is if I can't find truthful information through references, companies have gotten more into checking people's social media just because they want to get an idea about who you are, the information that you're putting out there. So that's the kind of thing you have to be very careful about. What social media channels are you using? What are you putting out there? And how is that going to make you look to a potential employer? Because it might be the kind of thing that turns them off. It might be something that disqualifies you if what you're putting out there is vulgar or offensive, or if you're trashing past employers, things like that, then maybe they just don't want to have anything to do with you. So be mindful of that when you're using social media. We'll take a minute to talk about a defense to wrongful termination suits. And one of those, there are several defenses, but one of those defenses is called after acquired evidence. So imagine a scenario where somebody lies on a resume. They say they went to Harvard, but they actually never went to Harvard. They just took a tour around Harvard, and then they say, well, I went to Harvard. Later, we find out that they're fired for a discriminatory reason. Then they file a lawsuit saying, well, I was wrongfully terminated because I was discriminated against. Now, the employer goes and starts digging into the case, trying to figure out what happened, what's going on here. As we're digging into the application, the resume, we find out they lied. And lying on a resume, according to our company policy, is something that is grounds for termination. So that could be a good defense for me later on when I find out, well, they shouldn't have been working here in the first place because they violated company policy by lying on a resume. Now, I didn't know that. I only acquired that evidence after the lawsuit. That's the after acquired evidence part. But that still can be a defense. So that's another reason why as I'm applying it, it's not always a good idea. Well, it's not usually a good idea to be lying on resumes because it can be the kind of thing that gets me fired later on and can damage my reputation pretty severely. And another example is we find out that we stole from the company. Same thing there. Even if the person was discriminated against, we later find out that they did something that would be a fireable offense. Then my lawsuit might go nowhere because of this after acquired evidence. Now, we'll talk just a minute about record keeping. So here we're talking about a company keeping records of who applied, who was hired, who wasn't, who was fired, what were those reasons, things like this. And it's a double-edged sword. If you're doing the right things as a business, it's a good idea to keep these records because it can be used to defend yourself later on. If there was a lawsuit or somebody's suing you for something and you don't think you did anything wrong. However, let's say you're a bad actor and you are discriminating intentionally and you know that you are. There are some people out there who still will do this. Keeping those records are the kind of thing that can really come and damage you later on. So, you look at some people who are really bad actors in the world. They don't like sending emails. They don't like people recording phone calls. They don't like doing anything in a written form because that might create a record that can come back to bite them later on. So let's just assume everybody is a good actor. Everybody is trying to do the best they can to build a legitimate business and do the right thing, contribute to society, all that, while still making money for myself, of course. Good idea to document these things. And then there are some statutes that will mandate that you keep some records. We'll get into a little bit more of that stuff later on. So let's switch to eligibility testing. We're just continuing this whole process of, recruiting people, having people apply, doing interviews, doing background checks, things like this. And part of that might be we're doing some eligibility testing as well. There can be all sorts of eligibility tests that companies can use. Some key words that we'll hear when deciding whether a test is fair and legal to use is it job related? Is it consistent with business necessity? Is it predictive of job performance? These are the kind of things that I want to test for anyway, because I'm just trying to figure out if the person will be a good fit and will be the best qualified person for the job. If later on we find out that, and we talked about this a little bit when we were talking about disparate impact, but let's say that I have a test that does result in discrimination, I need to dig a little bit deeper and say, is there a way to find out the same information, but in a less discriminatory way? If there is, then I should use the less discriminatory alternative. If there isn't, and it's still consistent with business necessity, predictive of job performance, then it might just be what it is. It just might be that there's a disparate impact there, but there's nothing that can be done about it. We want to test for job-related things that are justified by business necessity. This might require doing a job analysis to understand what kind of skills and knowledge are required for specific jobs within the company. To find out what are the things that we need to test for. There is such a thing called the Uniform Guidelines on Employee Selection Procedures, which creates some guidelines that will validate the tests to look at sort of like an employment test that I'm giving people. It might be like a multiple choice test, asking them to do some math if that's required by the job, asking them what they would do in certain situations to see if they're able to maintain composure, whatever the test might be. So there are certain types of validation that can be gone through. This is usually used by, larger corporations who are trying to get a test validated to make sure that it's going to be okay and is not going to be the kind of thing that gets me sued later on. But if it's the kind of thing you're worried about, then I gave you a link there. You can learn more about it. You can actually get a test sent in and validated to make sure you're going to be okay. And this is for people who might find themselves in an HR position high up in a very large corporation. For smaller companies, you're probably not there yet. Maybe as you grow, you'll get there. Sometimes companies will have people do integrity or personality tests just to see what kind of people we're hiring. We just need to make sure, again, that they're not discriminatory. So testing for things like conscientiousness, which we can demonstrate has a strong correlation to on-the-job behavior. So it makes sense. Maybe I can create a personality test that tests for conscientiousness, and we want to hire people who score high on that. Things like basic intelligence testing, also another predictor of job performance, probably also going to be fine. So we just have to make sure that the test is actually testing for those things in a consistent and fair manner, and then we'll be okay. Now, some companies, after doing a test, might get the results back and find out, this test discriminates against fill in the blank, whatever protected class. I feel it discriminates against Asian people or white people or black people or women or men or whatever it might be. And I can show this statistical difference and show that there is a discrimination happening here. Some companies might freak out and say, oh boy, now we need to go back and fudge the numbers and adjust the statistical results to make sure it doesn't look like we're discriminating. That's the kind of thing, well, we call it subgroup norming here, but it's the kind of thing that can get me in trouble later on. If the test has been validated, if everything is okay, and if it's in line with business necessity, And if we find out later there's a discriminatory impact and there's no less discriminatory alternative, then again, it might just be what it is. Some jobs will have you do a physical ability test. So thinking about jobs that are actually much more like physical labor related usually is where you'll have this physical ability testing. And again, that's fine. You just want to make sure you're testing for things they'll actually do on the job rather than just having them do some type of exercise like how many sit-ups can you do? How many pull-ups can you do? Because there's not many jobs that are going to require you to do like 10 pull-ups or something like that, for example. But let's say you're applying for a firefighter position and you need to demonstrate that you can carry this hose up 10 flights of stairs or whatever it might be, then we'll just have them do that thing rather than saying, all right, can you deadlift 400 pounds? Then that's going to be very discriminatory against women specifically. So just make sure that we're testing for what they're actually going to be doing. Medical testing can be done, should be done after, here's the key, after the offer of employment, but before the actual employment starts. If we're going to do medical testing, we should be testing everyone, not just singling people out because they might look a certain way or whatever it might be. There was a time in history when polygraphs became popular and people started to believe that they were very reliable lie detectors. So companies were toying around with the idea of using polygraphs in hiring. We find out later that polygraphs aren't that reliable. So we passed the Federal Employee Polygraph Protection Act. This bans polygraph use for most private employers, there are some positions where it might be okay, maybe okay for security personnel, maybe persons that are going to be handling controlled substances, could be okay for defense contractors. In a narrow case, it might be okay for a private employer in a case of suspected employee theft, where a person is reasonably considered to be a suspect. But it can't be the only thing that we use to take negative action against a person. There would have to be some additional evidence pointing towards it. But in general, polygraphs not that useful to employers, and you probably can't use them anyway. Most of us are familiar with the idea of drug testing. And I linked you to North Carolina statutes. You can learn more about the laws specifically for North Carolina. This is pretty widely accepted, pretty considered to be okay for hiring. We want to make sure that the people that we're hiring aren't on some illegal substance or even illegal substance during work hours, especially where safety and job performance can be impacted by somebody being intoxicated on the job. Commonly done in pre-employment in order to be considered for a job. If you fail a drug test, then you're automatically disqualified in a lot of cases. Now, there are some companies out there who will take somebody even though they test positive just because they need employees that badly. But for a lot of jobs, and especially higher you move up, then this kind of thing that can disqualify you. It's also commonly done after a workplace injury to help determine whether or not we're going to be liable for workers' comp as a company. So the company's going to want to try to cover themselves if somebody gets hurt on the job. And so it's very common if somebody is injured on the job, we do a drug test immediately. And if they're intoxicated, then I as a company can escape a lot of liability if the intoxication is the cause of the injury, or can convince a court that the intoxication was the cause of the injury. There are some ADA concerns there. The ADA could potentially cover somebody who has a history of drug use that led to a disability. It doesn't cover current drug users unless the drug is legally prescribed to treat or manage a disability, and if they can still do the job while on that drug. Okay, so it gets a little bit nuanced at that point. And then we get the question, because we're seeing a lot of states starting to legalize marijuana or cannabis. Call it whatever you want to call it. What about states where this is legal? Okay, well, in those states, at this point in history anyways, Employers are still given the latitude to ban use for employees if they want to do that. So even though it might be legal to use in your state, if the employer chooses to do so, they could still disqualify you from employment for using. And this could change. It kind of depends. We're already seeing some states like California considering legislation that might say, well, if it's a legal substance, and as long as they're not intoxicated on the job, then they shouldn't be disqualified for employment for using a legal substance. On that topic, North Carolina does have a statute about the lawful use of lawful products during non-working hours. So we're thinking about things like alcohol and tobacco are probably the biggest ones. Legal substances that are used, as long as we're not, alcohol would be the biggest one probably here, to make sure somebody's not intoxicated during working hours. But in most cases, I'm not going to be able to discriminate against somebody because they're using a lawful substance during non-working hours and it's not affecting their job. Another type of testing, it's not really testing as much as it is just verification of eligibility to work in the United States. This is the Form I-9. If you've applied for a job and gone through hiring, you've had to fill out one of these forms at some point, even if it's just digital. But it's used to verify the identity and employment authorization of a person hired for employment in the U.S. So you have to complete this form as a company each time you hire a person to perform labor or services in the United States in return for wages or other remuneration. That just means as long as you're paying somebody for a job, then you have to do this I-9 just to make sure they're eligible, either a citizen or they're otherwise eligible to work in the United States. Now, there's some exceptions. So people who are hired and have been continuously employed on or before 1986, okay. Casual domestic workers on a sporadic, irregular, or intermittent basis. Why would this be an exception? Well, because the people that are passing the laws are rich people. Rich people generally have people who are doing some domestic work at their house. They thought this might interfere with their ability to get cheap labor. So, hey, it's an exception now. Independent contractors, only because the independent contractor is supposed to have done their own verification, okay, on their end. If I'm employed by a contractor providing contract services, so we're thinking about temp agencies here. So if I'm using somebody who's been sent to me by a temp agency, I don't necessarily have to do that I-9 form because the expectation is that the temp agency has already done that verification for me. Or if I'm not physically working on U.S. soil, but for everybody else, you have to do that I-9 form. It's not a perfect system, but it's what we have. We learn a little bit more in the section where we talk about the IRCA. Okay, genetic testing. There was a lot of buzz about genetic testing. I think back in the 80s or something like that, when we started to be able to test people's DNA to map the human genome, to be able to do this kind of genetic testing. To determine if people have certain proclivities to develop certain diseases or disorders, then there was a lot of worry that, well, in the future, all employers are just going to do very invasive genetic testing. And if they find out that I may be more susceptible to developing cancer or certain disorders, then I'm just not going to be able to get hired anywhere. So at the federal level, they passed GINA, the Genetic Information Non-Discrimination Act, banning discrimination based on genetic information. And in North Carolina, we have a statute that says something very similar. Now, this kind of conversation is coming up more recently because we've become so much better at doing this genetic testing. And we're finding more and more tests to test for more and more types of diseases and disorders. So again, it's got people a little bit worried, but for right now, it's illegal to discriminate based on genetic information. Again, the HIV testing is another sort of a little bit of a time capsule maybe in here. So HIV during the 80s was so scary to people because it was so lethal that everybody was scared of anybody who tested positive for HIV. We were still learning more about that particular virus. And, you don't hear as much about it nowadays because we've become so good at trying to prevent transmission and also understanding how it's transmitted. I don't have to be afraid of everybody that tests positive for HIV, as well as becoming so good at treating it now to where it's not nearly as big a concern, at least in the United States, where we have the healthcare system we have. Now, that said, testing somebody for HIV, I have to be careful there because they might be protected under the ADA and the VRA. So it's not that common for companies to test for that. Okay, so conclusion to this little section of this lesson here. So 3 possible approaches for testing for ineligibility for a position. One is, okay, we can do mandatory testing for everybody. That way everybody's treated fairly because everybody has to take the test. One is we could have probable cause testing, where we test only when there is some suspicion of ineligibility. And I, as the employer, should have to be able to articulate the reason for suspicion rather than just making all the Asian people do the test or all the Black people do the test and not making the white people do the test. Things like that is what we're trying to avoid. And then the third possible approach there is random testing. So random testing, again, would be okay, but it should actually be random rather than just singling certain people out and then calling it random as a proxy for discriminating based on some protected class. Okay, so now we're moving a little bit farther along in the process here. We've recruited applicants, we've hired people on, and now we actually have employees now, and we can talk about performance appraisals. These are the things where we look at, well, here's what you've done. Now let's look at what you're doing well, what you can improve upon in order to continue to develop professionally. Okay, these are the periodic assessments of employee performance. You might do them once every year, once every 2 years, once every 6 months, however it is your company chooses to do these performance appraisals. You might not even do them at all. Especially small companies might not do them at all, or they might just do very informal things where if there's a problem, the boss comes to you and says, here's what you need to fix. And that might be the extent of it. But when we develop a system, as companies grow bigger and bigger, they usually develop some kind of performance appraisal system because the company's gotten so big that the owner can't keep track of everybody anymore. So we have to come up with a system. So when we have a system, it should be sufficiently job related. The person doing it should be reasonably free of bias. And the tool should measure a fair representation of what the common employee should be. What should our performance look like? Set some benchmark somewhere and see if people are meeting the benchmark or not. Where a performance appraisal system has a disparate impact, we're subject to scrutiny. We have to look at it and say, is there a less discriminatory alternative? Or is business necessity going to be a defense to us? And we set up this informal rule. The rule is set by the EEOC, but it's not necessarily etched into law. But it's called the 4/5 rule. So what it means is that when a minority group performs less than 80% as well as a majority group, then that draws our scrutiny. And now we need to start looking at, okay, is the system job related? Is it non-biased to the extent that we can make it? And is it fair? If there's a less discriminatory alternative available, we should use that instead. Otherwise, we can continue using it as long as we're able to justify it sufficiently. So management tips here: maintain proper documentation, train your supervisors on non-biased reporting and evaluations. That seems like it should be obvious, but it's not always clear, again, because we're human and we have our own biases, whether we're aware of them or not. We want to take precautions against inappropriate disclosures of information, especially when we're dealing with stuff like healthcare information. We want to evaluate frequently, systematically, and as stated in the employee manual or other policy documents that we develop. We want to make sure once we develop our system, we make sure it's fair, and then we want to use it fairly and as it's designed. But let's say we have a situation where we're going to have to discipline somebody because maybe they've violated policy in some way or not. Well, so a lot of people say we should adopt, companies handle discipline in many different ways. One of the ways that people say things should be handled is by taking the just cause disciplinary approach. This is where we establish a system of due process, meaning there will be an investigation. The investigation is going to be fair. You'll have a chance to hear the evidence against you. You'll have a chance to respond to it. We'll consider the appropriateness of the penalty and match that to the severity of whatever policy breach there was, and trying to create that fair, that just cause disciplinary approach. Other companies have like a no tolerance approach, where if you violate a policy at all, then you're just gone, and there's nothing more to it than that. And it's not that one is more legal than the other. We're just trying to figure out a good way to manage an organization here. And a lot of people think the just cause disciplinary approach is the best. But ultimately, you go out and start your own company. You get to decide what your approach is going to be. It is a good idea to document things here, just again, to cover us later on. If there is a lawsuit, we'll be able to pull those records and demonstrate, here's why the person was fired. We kept documentation here. So even though they're accusing us of discrimination, the unfortunate matter of the fact is that they violated company policy in many different ways, and we had to let them go. If we're going to be interviewing somebody in an investigatory interview, the employee does have the right to have a coworker present, just so there's somebody else there that can verify the things that are said. Okay. That wraps it up for this lesson. I hope you all have a great day.